Hey guys, what's up? So this is the new series. We continue in the polity series, and it will be dealing with the constitutional amendments. Basically, amendment can be done either in constitution or in a law or in a policy or in an act or in a contract. Anything can be amended, but specifically we will be dealing with the constitutional amendments. Rest are not important at all. This is the part 6.1. I think I'll make one or two more videos in this, and this is the YouTube channel Unacademy. So like always, if you have any doubt or any query or any comment, or if you like the video, hitting the thumbs up, whatsoever is the thing going on in your head, I would like you to express yourself below the video on YouTube or on the Facebook. I will read them. Maybe I will not reply to you, but I will read them and I'll try to incorporate in my next videos. This is the Facebook page. So, what do you mean by constitutional amendments? Basically, amend means to change, like you make amends with your friends or something like that, like you improve something. That is called as amendment. So, it is formal, it is a very formalized process. It's not very easy in any constitution in the world, and it is an official change which is made to any legal document. This is a keyword. If you are talking only and only about amendment, अगर सिर्फ amendment की बात हो रही है, then it can be done to anything, law, contract, any act, any policy, any constitution. But specifically we are dealing with the constitutional amendments. So what does it do? It either can add a part, like completely new part, okay, then it can remove something obviously, and then it can update or edit any part. So these are the basic three provisions which can be done under any constitutional amendment act. Why is it needed at all? Let's say 1950, there were no, most of the time there was no terrorism, okay, there was no internet, there was not much emphasis on education in that time, so it was not a fundamental right. Similarly, right to property was considered sacrosanct, but then it came difficult in land acquisition. There are so many provisions which cannot be envisaged means seeing in future and seeing it happening by our founding forefathers, obviously. Then what they leave is the scope of flexibility and to adjust to the changing conditions and needs, so that you can adapt. Otherwise the document will perish, because it has to be a living, vibrant, organic document. If you do not allow scope for changes, first of all, our constitution has like something like 1,17,000 words. It's a huge constitution, more than 450 articles. It is one of the longest constitution in the world. Most of the constitution are not even 20% of our constitutions. Since it is so elaborate, so the powers are restricted sometimes because of certain words. So you need to have that flexibility in such a long constitution, and so that it can adjust to the changing environments. In case of Britain, obviously the thing is parliament is supreme. Since parliament is supreme and the constitution is not written or codified, so it is extremely easy to amend the constitution. It's just like simple majority is needed. Like any ordinary law, constitution can be amended. In USA, the law is the supreme, so it is extremely hard to amend the constitution. I'll come to the US case. Why is it very hard to amend the constitution in case of US of A? In case of India, we have a mixed approach. We have a synthesis. It is neither very rigid, nor it is very flexible. So it is best of the both worlds. Meaning ruling party, let's say if it has majority, so it cannot amend on whims and fancies. It cannot just go about and change the entire constitution. Similarly, you do not really need too much of a support from other people. If some MPs allow you to amend it, you can easily amend it. So neither it do not give an absolute power to amend it, plus it also restricts you, and it also enables you to do it very easily in certain other circumstances. We will know in detail now. So in case of US of A, that is United States of America, when it comes to constitutional amendments, it is extremely hard to amend the constitution. Each and every one of you should know. It came into force on 25th of September 1789. Various amendments were introduced. So in 1789 it came into force. Until then 11,500 proposals approximately in last 226 years. You know how many have passed? 27 have become Constitutional Amendment Act. Out of this 27, 10 were enacted within 2 years, that is on 1791. So they do not count because they are more or less part of Constitution. So only 17 in last 224 years. 4 are still open, 2 have failed after being passed by Congress. So total 33 have been passed by Congress. 33 passed by Congress in last 226 years. What is Congress? Just like we have Parliament and we have upper house and lower house. Similarly, US have a Congress, and the lower house is called as House of Representative, or simply the House. It has 435 members, maximum coming from California, that is 53, and minimum from several states like Wyoming, etc. They have just one. 7 states have one. Their upper house is called as Senate. It is one of the most powerful upper house in the world. It has 100 members, and it is not dependent on population of state. 50 states are there in USA, so 2 from each state will come. Whether it is a small state of Wyoming or Hawaii, or whether it is a large state of California, it does not matter. The population does not matter. Unlike in India population matters even in Rajya Sabha, but there it does not matter, and 100 people are present in Senate and 435 in House of Representatives. This body is called as Congress, just like Parliament in India. So Bill of Rights, what does Bill of Rights include? They are one of the most fundamental rights. First time in the democratic constitutional written form they were codified, and they came functional by December 15 of 1791. The first is freedom of religion, press, speech, and peaceably assembly. Second is to right to keep arm and bear. Third is that you cannot allow soldiers to come in peacetime to stay in private citizens house. Then no unreasonable search, there should be a need of search warrant. Then there is due process, extremely important. This is the first time it is mentioned in a democratic constitution. Then no self incrimination is allowed, like you can't be compelled to give evidence against yourself in a trial. No double jeopardy is allowed. It is also present in Indian constitution, fundamental right. No double jeopardy means that you can't be compelled. Article, just go to article 20, that you can't be punished for the same crime twice. Then right to trial by jury. And finally, it prohibits excessive punishment. You cannot give arbitrary punishment or cruel punishment. And it even protects right outside constitution. This is the 9th amendment or 9th bill of right, and this is the federalism. Federalism means that only those powers can be enjoyed by the federal government which are given to it by state and the people. It is unlike in India. India is a union of states. There it is not. Their states have made a contract. It is one of the most perfect federalism in the world, United States of America. Then we come to the proposed. How does the amendment actually happens in USA? See, proposed amendment is sent to the states. States means 50 states of USA. Earlier they were less. When it started out, it was 13 states, 13 colonies, as you might be knowing. So first of all, it can either start passed by United States Congress. In that case, what will happen? 2/3 majority is needed in both Senate. Senate के केस में 67 वोट्स चाहिए. हाउस ऑफ रिप्रेजेंटेटिव के केस में 2/3 of 435 वोट्स चाहिए. Or a national convention can also be called by Congress, and in that case, only and only when 2/3 of the state legislature, that is 34 out of 50 state legislature, if they want, a national convention can be called. ये तो हो गया भाई स्टार्ट करने का प्रोसेस. नाउ हाउ टू बिकम पार्ट ऑफ द कॉन्स्टिट्यूशन, हाउ इट कैन बी एक्चुअली पास्ड. अब एक बार अगर कांग्रेस ने पास कर दिया 2/3 मेजोरिटी से बोथ हाउसेस में, और a national convention has been called by 2/3 legislature, so in that case, now to pass it, 38 of the 50 states, that is 3/4 of the states legislature need to pass it. There might be a attached time limit to it, or there might not be, we don't know. Or either it can be passed by state ratifying conventions, so either by the legislature or by the state ratifying convention, again in the 3/4 of the states, which is present number is 38. Now there are various few amendment. 10 तो बता ही चुका हूँ. They are deals with Bill of Rights. तो जो rest 17 में कुछ important है. 11th talks about sovereign immunity. It means that no outsider can sue the United States. That is, no foreigner can sue United States. 13th Constitutional Amendment Act, one of the most important amendment act done by Abraham Lincoln. Must see the movie Lincoln. It abolished slavery in USA except as a form of punishment. Then 15th Constitutional Amendment Act that is again a good thing, a positive approach to ending the racism, that is no denial of right to vote on base of race. Then 18th Constitutional Amendment Act, it is one of the most controversial act of 1919 era. You must have watched movies like Great Gatsby and all those Tom Hardy movies, where they deals about how illegal construction of various places occurred to make alcohol and sell it. So organized crime got a push during this era. Also the taxation got reduced, so which was needed in the time of 1929 Great Depression. Anyway, it was repealed after 12-13 years in by 21st Constitutional Amendment Act. Now 22nd Constitutional Amendment Act, it deals with that a president cannot have more than two elections. And let's say if president steps down and vice president becomes the president, and if he has served for 2 years, then he can get elected for 2 years, two terms more. So maximum of 10 years can be served. If he serves more than 2 years as president, being a vice president, that is, he was not elected, so in that case, he can be elected only for one more term. So is that understood? So 10 years is the maximum period in which US president can stay as US president. Now 26th Constitutional Amendment Act, it was passed in 1971. That is more than 18. If you are more than 18, there is no denial of vote to you. And this is the last amendment which was passed in 1992. It just prohibits that you can't increase or decrease the salary of congressmen after the next session start at least. It was submitted in 1789. It was passed in 1992. That is, it just took 202 years for it to be passed. And there is no amendment in US Constitution since 1992. So just to give you a taste of how difficult it is to amend a constitution in USA. Amendments in Indian constitution or Indian context, what it deals with. Basically, we have seen in last 1950 our constitution came into force, and today is 2015. So total 65 years have passed. 121 constitutional amendment bills have been introduced in the parliament, out of which 99 have become constitutional amendment acts. Out of this, latest one was National Judicial Appointment. That was the bill which was, and it has been passed as 99th Constitutional Amendment Act of December 2014. Deals with the judicial appointment. Now, three type of amendments are there in Indian Constitution. It can be done by simple majority, it can be done by a special majority, or it can be done by a special majority plus half of the state ratification. Is that absolutely understood? What does it deal with? Simple majority means here any ordinary law, how do you pass it? More than 50% of member present and voting. Quorum होना चाहिए. So let's say there are 55 members in Lok Sabha. So that forms a quorum. Yes, quorum means 1/10 of the member. Or there are 25 members in Rajya Sabha. So you just need vote of, in this case, 28 members to amend the constitution. And in this case, you just need vote of 13 members to amend the constitution under simple majority. So they just need ordinary legislature, that is 50% plus 1 of present and voting, not the total strength of the house. And it does not come under purview of Article 368. So it will not be seen as 66th Constitutional Amendment Act. इसको कोई नंबर नहीं मिलेगा अपना. So Article 4 क्या कहता है? Whenever you amend under Article 2, that is whenever you establish new states or admit new states, or Article 3 when it relates to formation of new states or alteration of their area, name, boundary, which leads to 1 and 4 schedule be amended. Obviously 1 and 4 will be amended, right? And any consequence or any supplement or incidental matters, it shall not be deemed as amendment to the constitution. Is that absolutely understood? This was the simple majority case. Other case includes these case whenever you are talking about legislative council, either their abolition or creation. So in 7 out of 29 states we have it. They include Andhra Pradesh, Bihar, J&K, Karnataka, Maharashtra, Telangana and Uttar Pradesh. They are big states. All states are very big states. Assam and Rajasthan have been cleared by parliament, and the states may or may not appoint it depending on their mood. Then Schedule 2, 5 and 6. Schedule 2 deals with salary, emoluments, etc. 5 and 6 deal with the administration and tribal areas. 1 and 4 I have already talked to you about. So they can be amended by simple majority. Then parliamentary provisions like salaries and allowances of MPs, rule of procedures, privileges, members, committees, use of English language in parliament. Again, they are not very big things, so they can be amended by simple majority. Then elections to the parliament and state legislatures, delimitation of constituencies, any matter related to union territories, number of puisne judges in the Supreme Court, conferment of more jurisdiction on Supreme Court. So these are all matters which are not covered under Article 368, but they are part of constitutional amendment. Finally, use of official language and citizenship provisions. So these are all the matters which can be dealt solely by simple majority. Now we have case of special majority, which is everything which is not covered by 1 and 3rd category. Everything is special majority. Example, anything which deals with fundamental right, anything which deals with directive principles. There are just few examples, and most of the amendments will happen under special majority. Now comes the case of special majority plus 15 states. Earlier it was 14 states, now it has become 15 states because constitution says half of the states at least. So earlier 28 का half होता था 14, now 29 का half होता है 14.5, but at least बोल दिया तो 15 होना चाहिए. So federal provisions, whenever it deals with federal provisions, so there is no time limit on the state if it does not do within time limit, or if it do not do within the stipulated time, or it does not take any action, either of the two cases, nothing is absolutely going to happen if 15 of the states have ratified. Is that understood? Let's say 14 states do not do anything at all. They don't do it in time limit, they don't say yes or no or abstain. But if 15 other states have passed, so it does not matter, the constitutional act will become part of constitution. एग्जाम्पल क्या होंगे? अब प्रेसिडेंट है दैट हैज़ बीन इलेक्टेड बाय बोथ MPs एंड MLAs. सो द प्रोसेस ऑफ इलेक्शन ऑफ द प्रेसिडेंट जो होगा दैट इज़ अ फेडरल फीचर. देन हायर कोर्ट्स, ऑब्वियसली कोर्ट फॉर्म्स अ बैकग्राउंड ऑफ फेडरल फीचर्स. हाई कोर्ट्स और सुप्रीम कोर्ट से डीलिंग एनीथिंग एट ऑल विल बी फेडरल प्रोविजन. 7th शेड्यूल में लिस्ट होती है कंकरेंट लिस्ट, स्टेट लिस्ट और यूनियन लिस्ट. So if anything happens to those lists, any change that needs to be 15 states need to pass it. Then state representation in parliament, obviously. Then balance between executive and legislative power of central and state, that is central state relationship. And finally we have Article 368 itself. You can't amend Article 368 without calling for 15 of the states. So moving forward now, so Article 368 and Part 20 of the Indian Constitution, what does it say? It deals with the powers of parliament to amend the constitution. Not only deals with the power of parliament, it somehow limits them also, as well as it deals with the procedure. How can the amendment start, or how can the amendment happen? Then parliament in its constituent power. So this is how keywords are written. Some of you are asking me to how to make notes. This is how you make notes without writing the entire definition. Parliament in its constituent power can amend. What do you mean? Addition, variation or repealing. जो मैंने पहले बताया था. Any provision of the constitution by following a proper procedure. So these are the 5 keywords. And no basic structure can be amended, obviously, which has been known after 24th April of 1973, case 1 and the Bharti case. So what does doctrine of basic structure deals with? It deals with the procedure which is laid down in Article 368, and it keeps the parliament in check as far as its amending power are concerned. Is that absolutely understood? So doctrine of basic structure plus the Article 368, it will keep the parliament in check. What is the procedure under Article 368? It is very important, and I think you can get 1 or 2 MCQs from it. Introduction can happen only in parliament. अभी US के केस में क्या बताया था? State can also introduce by 34 states if passed by national convention, and only by either in Lok Sabha or Rajya Sabha, but not by state legislature, by any MP, where both ministers and private members can introduce it. But obviously it will become difficult for private members to introduce it. Cannot be introduced in state legislature at any cost, and no prior permission of president is needed. This is also understood. But if you are creating new states, then prior permission of president is needed. Special majority is needed in each house. Is that understood? Now what is special majority? Many people have confusion regarding this, so I'll totally demolish your doubts now. 50% plus 1 of total membership. अब इसमें वैकेंसी इंक्लूड नहीं होती है. टोटल मेंबरशिप ऑफ लोकसभा इज 545. टोटल मेंबरशिप ऑफ राज्यसभा इज 245. इज दैट एब्सोल्युटली अंडरस्टूड? तो इसमें अगर कोई वैकेंसी है, किसी की डेथ हो गई या किसी ने रिजाइन कर दिया, इट डज नॉट काउंट एट ऑल. यू हैव टू कंसिडर द टोटल मेंबरशिप. लेट्स से राज्यसभा में आपके 15 मेंबर नहीं है, तो 230 इज द प्रेजेंट मेंबरशिप. नो, प्रेजेंट मेंबरशिप रिमेन्स 245 प्लस द 2/3 और मोर ऑफ प्रेजेंट एंड वोटिंग. सो अब एग्जाम्पल क्लियर कर देते हैं. मान लो लोकसभा में 55 मेंबर्स आए हैं, सो लोकसभा विल रन, एब्सोल्युटली इट विल रन, बिकॉज 1/10 मेंबर्स आर नीडेड टू फॉर्म द critical number that is called as quorum in Indian context, 1/10. But can they amend constitution under article 368? No, you still need at least 273 votes. Let's say 300 members are present in Lok Sabha, so 200 are needed as per 2/3, but still you need 1.5 of 545, that is 273. So minimum number of votes required is 273. उससे कम में तो बात ही मत करो आप कॉन्स्टिट्यूशनल अमेंडमेंट की. Let's say all members are present 545, then the number of votes required is 2/3 of 545, that is 364. So between 273 to 364 votes, constitution can be amended by Lok Sabha. So, but theoretically, since 552 seats are possible, that is 530 seats, do you know that earlier there were only 525 seats in Lok Sabha, and by a constitutional amendment act it was increased to 545. I don't think many of you will know this. Anyway, so out of 552, 530 comes from states, 20 from union territory, and 2 from Anglo-Indian community. It is the maximum possible strength, but in present practice it is 545. So at least 273 is the minimum number of votes and 364 is the maximum number of votes. So let's say 400 members are present, 402. So if you just do it by this, what you will get is 804 divided by 3. This is how people do the calculation slowly. 804 divided by 3, that will give us 2, and that will give us 6, and that will give us 8. So 268 members. Now can it amend? No. Answer is again 273 at least are required. So they can ask you certain questions and then you have to apply the logic. Now what is the maximum possible votes which is needed in Rajya Sabha? Let's assume there are 245 members, entire strength is present. So there are 233 elected plus 12 nominated out of 4 fields. You know those: art, science, public social service and literature. So 245 का अगर आप 2/3 करते हो तो that comes out to be 164. Let's assume 250 is the maximum possible strength. In that case 167 votes are needed. But let's say only 25 members are present, which is the quorum. But you can't amend it by having lesser number of votes than 123. So at least 123 votes are needed, because 1/2 of total strength, that is 245, is needed. Our maximum votes which are needed are 164. So 123 to 164 is the range of Rajya Sabha, and here the range is 273 to 364. Please remember them. Answer will be in between these ranges only. Now other provisions are: separate passing is must. It cannot be कि भाई अब जॉइंट सिटिंग बैठा दो, अब डेडलॉक हो तो. नॉट जॉइंट सिटिंग इज अलाउड एट ऑल. एनी केस इंडिया में सिर्फ 3 ही जॉइंट सिटिंग हुई है आज तक, ऑर्डिनरी लेजिस्लेशन में भी. विच वॉज द लेटेस्ट वन? प्लीज फाइंड आउट. इट वॉज रिलेटेड टू प्रिवेंशन ऑफ टेररिज्म एक्ट. So if federal provisions are being amended, now comes the half of the states must ratify it. Earlier it was 14, now it is 15. Formation of Telangana with the simple majority in their own legislature. ये समझ में आ गया ना, अपने legislature में simple majority चलेगी उनके. And once both the house passes, that is Rajya Sabha and Lok Sabha plus 15 states if needed, then it is presented to president. Now comes the catch. Before October of 1971, president has the pocket veto also. He could sit on that and he can even return it. But after 24th Constitutional Amendment Act, president has to compulsorily give his assent to the Constitutional Amendment Act. He can't withhold it for pocket veto, nor returning is allowed to the parliament. And once the honorable president signs it, it becomes an act and constitution stands amended. Is that absolutely understood? Now what is the criticism of India's process? No special body. Like I told you, national convention was there in case of United States. So no special body is present for amendment like constitutional convention or national convention or a constitutional assembly, etc. You give all the power to parliament only. Parliament legislate just like ordinary legislature, and parliament are also doing constitutional amendment. And secondly, you do not allow the federal features to take place. It is not allowed to be introduced in state, unlike in case of US of A. Except for creation of legislative council, it cannot initiate in state. And even in case of legislative council, अगर state pass कर भी देता है, parliament can set up on it, parliament may approve it, parliament may disapprove it, it's totally up to them. Now, majority of the constitutional amendment acts, there is absolutely no need of states. Is that understood? Why is that understood? Because most of them, if it is by default, it falls into the second category. Even if you need states in case of federal provision, it is needed only in 15 out of 29 states need to pass it. USA में देखो भाई, कोई भी amendment करोगे, you need to be passed by all the 38 states at least, and every constitutional amendment act has to go to the states. 38 out of 50 is a big number. No joint sitting is allowed at all. So deadlock होगा तो बस अगर वन ऑफ द हाउस डिसाइड्स कि भाई पास नहीं करना है तो कुछ नहीं कर सकते फिर आप, अनलाइक इन मनी बिल और अदर इम्पॉर्टेंट बिल्स. एंड एक्सेप्ट द नंबर ऑफ वोट्स नीडेड आर स्लाइटली मोर, दो आई एग्री. 273 से 364 वहाँ पे है, बताया था अभी आपको, और 123 से 164 वहाँ पे है. सिमिलर जस्ट लाइक एन ऑर्डिनरी लेजिस्लेशन. अगर ये नंबर हटा दिया जाए तो इट इज़ जस्ट लाइक एन ऑर्डिनरी लेजिस्लेशन, नथिंग स्पेशल अबाउट इट. बट इट इज़ दिस सिंप्लिसिटी इज अमेजिंग यार. उस टाइम पे इतना होता ही नहीं था इंडिया में, कॉम्प्लेक्सिटी कर देते तो अमेंड ही नहीं होता, समझ में ही नहीं आता लोगों को करना क्या है. So the process is so simple and it strikes the right balance between rigid and flexible according to Weary. And it is as solid and permanent as it should be. Jawaharlal Nehru said this statement. It is as solid and permanent as it should be, but not anymore. Because it is need to be a living, vital and organic document. Vibrant मैंने ऐड कर दिया अपनी तरफ से, अच्छा लगने के लिए आंसर, नंबर ज़्यादा मिलेंगे. Living, vital, vibrant and an organic document. Now Dr. B.R. Ambedkar, he said that assembly has not only refrained from making it final and infallible, it has not denied the people the right to amend, nor is it set extraordinary terms and conditions. Is that understood? It has provided a facile procedure for amending the constitution. It's a very big words coming from father of our constitution. Recently we celebrated 125th birth anniversary of Dr. B.R. Ambedkar. We are truly indebted to him for creating this wonderful piece of document. Now Granville Austin, he said that amending process has proved itself one of the most ably conceived aspects of the constitution, and though it might appear complicated, it is merely diverse. And Casey Weary says that this variety in amending process is wise but rarely found. So these are the, आपको अगर फेवर में लिखना हो तो 5-6 कोट कर देना, अच्छे नंबर आ जाएंगे. So I hope you like this video, and I think I'll continue this amendment series and then we can talk about memory techniques and reading comprehension. So this is the YouTube channel Unacademy. This is a Facebook page. For your comments and doubts, everything, you can go here. You can also tweet to me at my Twitter handle. I'm more active here. And please spread the word and help those who cannot afford the coaching. And thank you for watching the video. Have an awesome day.